Well, I think we should turn to the Home Affairs Select Committee, actually, because here is Theresa May giving evidence on this and other matters.
This is part of the normal investigations that the committee conduct into the work of the Home Office. The Home Office comes full committee at least once a session. But we've moved this time, for those of you who expected this tomorrow, the time has been moved with the Home Secretary's agreement to today, because some of the aspects that we wish to probe and examine the Home Secretary on concerns the emergency legislation going through Parliament tomorrow. Home Secretary, can I congratulate you firstly most warmly on becoming the longest serving Home Secretary since Rab Butler in 1962.
I suspect it goes downhill from there, Chairman.
Did you celebrate that event?
No, I'm not somebody who sort of celebrates those sorts of things. Frankly, I just get on with the job.
Well, as you get on with the job, the last couple of weeks have been somewhat shambolic. You've had the resignation of your special advisor, who I know is, and the committee knows, you valued greatly, for putting an unauthorised statement on the website. We've had the crisis in the passport office, where thousands of British citizens have been waiting for their passports. We have had the revelation that 114 files went missing from the Home Office, something that the Permanent Secretary knew about in July of last year and you knew about in October of last year. And today we've had the resignation of Lady Butler-Sloss as the head of the inquiry that you had established. I mean, we all acknowledge that being Home Secretary is not like a walk in the park, but the last few weeks have been quite a surprise for a government department that we thought was extremely well run under your stewardship. What has gone wrong? Why is it all unravelling?
Well, first of all, Chairman, I reject any suggestion that it is, in your words, all unravelling. Yes, there have been issues we've had to deal with. If I look at the question of the Passport Office, we had obviously discussed this in a number of forums on the floor of the House of Commons. The number of applications for passports this year has been significantly higher than we have seen at any time for the last 12 years. Passport Office has now had well over 4 million applications for passports, and the number of applications in June was the highest month in the last 12 years. And the Passport Office over time was putting increasing contingency arrangements in place. Those contingency arrangements have continued and continue to kick in terms of their effectiveness. And obviously we watch what is happening at the Passport Office. And as you will know from the statement I made to the House, we put a number of extra measures in place to ensure particularly that those individuals who had an urgent need to travel and whose passport was not being dealt with in appropriate timescales were able to have an upgrade of their dealing with it for
We'll
free.
come on to the detail of the Passport Office later.
That was being dealt with. This was an issue that had arisen over a period of time, and it was dealt with properly as it should have been.
Indeed.
In relation to the other issues you mentioned, I mean, 114 files, you may come on to that question of the reviews and so forth in more detail later. That was, of course, something that was uncovered as a result of the review that the Permanent Secretary very rightly put in place last year and reported to him last year. Well, I'm very sorry that Baroness Elizabeth Butler-Sloss has resigned from the position of chairman of the inquiry that was taking place, the review panel that was taking place into the whole question of how the state and other institutions protects children, has done historically, and whether what lessons we need to learn from that. I recognise there's been a lot of suggestion and innuendo around in relation to Baroness Butler-Sloss. I reject entirely any suggestion that she wasn't the right person to do this, but she has to do the job. She has taken the decision herself. I'm disappointed. I continue to consider her to be somebody of impeccable integrity.
Yes. Can I first of all agree with you on that? I think all on this committee regard Baroness Butler-Sloss as being a person of the highest integrity. There's no question of that. But we were only given her name last week, just before Mr. Sedwell gave evidence. And I said to Mr. Sedwell, was it wise to appoint someone who is a Member of Parliament into an inquiry that may well result in issues to do with Westminster being the subject matter of that inquiry? Who did you consult before you appointed Lady Butler-Sloss to this very important job?
Well, obviously a number of discussions were held about the appropriateness of Baroness Elizabeth Butler-Sloss to head this inquiry. I myself believe that it was not only her integrity, her experience as a High Court judge, as President of the Family Division, but also as the individual who oversaw the Cleveland child sex abuse inquiry as well, so therefore bringing a historic expertise of a historic issue into the inquiry, that I felt was absolutely appropriate for her to be appointed to this role.
But what is surprising is that if you'd asked anybody the question about appointing Lady Butler-Sloss, the first thing that they would have said was that she was a member of this House, when this House is, of course, under scrutiny, even though she was a crossbencher. Secondly, that her brother was the Attorney General at the time when some of these allegations were being considered. And thirdly, no government minister went onto television to defend the appointment that you had made over the last week. I think the only person up before the cameras was her nephew, who is an actor and has claim to fame was that he appeared in a very famous sitcom in the 1990s. I didn't see you going forward to defend your choice of someone who you regard as being such an important person in order to run this inquiry. Nobody seemed to come forward to defend her.
The Home Office was very clear in the statements that were made, that were put out, that we absolutely defended Baroness Butler-Sloss's appointment. Of course we did. I put the name forward and made the appointment for her, and I continue to believe that she would have done an excellent job given her experience, her expertise and her absolute integrity. And you say, Chairman, that anybody would have said that she was a member of Parliament, as being a member of the House of Lords, and you question the appointment of somebody as a member of one of the houses of this Parliament to chair this inquiry panel, because, as you say, it could be that there were individuals formerly within this House, indeed names have been raised in the press. But I have to say to you, Chairman, that names of people potentially in a number of areas of activity, or the suggestion that a number of areas of activity in public life might be involved. We've already seen some of the historic issues that are related to individuals who are, to use the term, celebrities. And there are other questions that have been raised about the involvement of people. So it isn't the case that there is somewhere, somehow, a category of person who is in such a category that potentially...
But look how careful you were last year when you were offered a report that contained the names of senior politicians. You declined to even read that report. You said you wanted nothing to do with that report. In the case of yourself and probity, you decided to turn your face away from it. Yet you have appointed someone who had strong connections to the British establishment, obviously, as a former High Court judge, related to a former Attorney General, who was a Conservative Party politician, and someone whose whole record would have been looked at very carefully in respect of these matters. Do you not regret making that appointment? Or at the very least, do you not think that you should have had the panel of experts appointed with the chairman or chairperson at the same time that that appointment was made?
I do not regret the decision I made. I continue to believe that Elizabeth Butler-Sloss would have done an excellent job as chairman of this inquiry. She herself, I think it's a mark of the woman, actually, that she herself has come to this decision. I respect it. I'm disappointed, but I respect it. She's been clear in the statement that she's made that she was concerned about the willingness of victims to look with confidence on the inquiry because of some of the suggestions that had been made, and has come to her own decision.
But she has shown better judgment, has she not, than the government? This is the due diligence that you and your officials should have carried out. You shouldn't leave it to someone of the stature of Lady Butler-Sloss to say, I can't stay on, MPs are attacking me, so therefore I have to go. This is a matter of judgment. This is what you should have done.
Chairman, discussions were held. Of course, consideration was given to the name of Elizabeth Butler-Sloss and to the appropriateness of her as an individual to chair this inquiry. I continue to believe that it is absolutely right that Elizabeth Butler-Sloss is a woman of impeccable integrity, and I believe that her expertise and experience would have been valuable in leading this inquiry. That is the position which I continue to hold. She has taken her own decision that she doesn't feel it right for her to continue. As I said, I respect that decision. I'm disappointed because I think she would have done an excellent job.
When do you think we will have the new name?
I'm not able to give you a timetable on that at the moment, Chairman, but I can assure you that we will, as soon as we have a new name, we will ensure that that name is made known publicly so that people are aware of it, and we won't be hanging around, but I'm sure you will understand that anybody who is now approached we will want to have discussions with, and they will want to think carefully about the nature of the role.
Can I just gently suggest to you, Home Secretary, that you should consult more widely than the current circle of people that you may be consulting, perhaps with some of the groups affected, the child victim groups and others, so that the person you appoint is someone who commands the respect of all, and that there is no question otherwise that they would be in the invidious position that Lady Butler-Sloss appears to be, where her background is being questioned in this way. So perhaps the widest possible, rather like on Levinson, where the Prime Minister went out of his way to consult with Parliament and other party leaders. This should go beyond party politics, I'm sure you agree. So a wider degree of consultation may be wise.
I would want to ensure that, of course, the individual who leads this inquiry, and they will, as you yourself have indicated, Chairman, they will be supported by a panel, but I think it's appropriate that the panel is appointed in consultation with the Chairman, rather than being a fait accompli presented to the Chairman.
You don't think the panel might elect a Chairman to let you off the impossible task of choosing someone who has the virtue of Mother Teresa, because anyone appointed is going to be subjected to a great deal of scrutiny? Do you not think that you should have your panel of experts and allow them to elect their own chair?
I think it is appropriate that we appoint somebody to lead this inquiry, supported by a panel, as indeed has happened with previous panels of this sort, which are not obviously the full statutory public inquiry, but this review panel model that we're using at the moment.
Thank you. Could I have questions from colleagues on Lady Butler-Sloss, and we'll move on to the other issues? Yes, Lorraine Fulbrook.
Chair, it's more specific about the two inquiries, if you don't mind.
Anything about Lady Butler-Sloss? Yes, Ian Austin, and then...
Well, it's now clear that we've got the child abuse inquiry has no chair, it's got no terms of reference, and it doesn't seem to me to have any agreed purpose. How can the public have any confidence in this process?
Well, first of all, I've indicated about the membership of the panel that I think it's appropriate that that is discussed with the Chairman. I think it's also appropriate on an inquiry of this sort that the terms of reference are discussed with the Chairman. That is normal practice, and that is the practice that we will be following. And of course, when we have a Chairman appointed, we will be discussing the terms of reference. But I think we're very clear. There's some very clear points about this inquiry, talking about the more general inquiry that Baroness Butler-Sloss would have been chairing, which is it is looking at the issue of the protection of children. It's looking at what has happened. We've got the experience of a number of historic cases. We've had a number of reports and reviews into, for example, hospitals in relation to Jimmy Savile. There are other reports and reviews as well. They will look at documentary evidence. They will have the power to be able to call witnesses. They will look at those historic cases, say what went wrong. They will look at today and see, is this something that could continue today? Is there more that we need to do today in order to protect children? If I may, just this other point, because I think this is important. It is not an inquiry which is looking into individual allegations or allegations against specific individuals. If there is an allegation of abuse against an individual who it is alleged is a perpetrator, that should go to the police. That will not be for this inquiry panel.
Okay, so just to be clear, the purpose of this is to focus on lessons that should be learned. It's not a sort of investigating tribunal.
No, it's focusing on lessons that should be learned, which is what both I and the Prime Minister made clear last week when it was announced.
Okay. Just one final question. Will you be looking at the situation in relation to the barring register? Because as I understand it, there's been a 75% drop in the last 3 years of convicted sex offenders being barred from working with children, even though reported child sex abuse is up, not down. So can you guarantee that none of those people will be working anywhere, even supervised, with access to children?
Well, the reason that the figures have changed in relation to the disclosure and barring scheme, which has taken over from the previous vetting scheme that was in place was because it was considered that it was better to focus on people who were working with children. There were certain categories of individuals who were not working directly with children, who previously would have been included in the automatic barring regime. As to whether or not that regime is looked at by the panel, it will be for the panel to consider whether that is part of the issue that they need to look at in looking at today's protection of children.
We'll come on to the other inquiries then. We're just on Lady Butler-Sloss and then we will move on. Mr. Ellis first.
Thank you, Mr. Chairman. So, as far as the Lady Butler-Sloss issue is concerned, that inquiry, that panel inquiry, is about institutions and about aspects of the British system, such as the judiciary or the church or institutions like that. And that's going to be different from the Wanless review, which is about following up the missing files and things. Can we just establish there's a difference between these two, and because they're being conflated in some quarters? And am I right about that, first of all?
Yes, you're absolutely right about that. And it is the case that, and I've seen some comments attributed to people where they do appear to be mixing these two. There is a review which is about lessons learned and the protection of children. There is a review which is looking into work that was done in the Home Office, which resulted from this question of whether Geoffrey Dickens had passed information to a previous Home Secretary and whether that had been properly dealt with, or whether in sense that had been in some sense covered up. And there was a review on that, but we're now having a further review to make sure that everything that was done by the Home Office was done absolutely properly.
And Lady Butler-Sloss has stepped down very, very early in the proceedings, so no terms of reference have deliberately been calculated yet because you want to discuss those with whoever the chairman is. But do you anticipate a difficulty in finding a replacement in as much as it's been suggested that a peer might not be suitable because of the connection to Parliament, but it's also been suggested elsewhere that a judge might not be suitable because part of the establishment. Potentially, I suspect there are others in leading figures in the establishment who might not be suitable either. So how long do you think it will take to find someone who is going to accept this responsibility?
Well, I can't put an absolute timetable on it. I'm sure we will be able to do so within what I would call a reasonable space of time, so that there can be absolutely no doubt for people who will chair this. But I think the point that you make, that obviously there are people who are saying that all sorts of categories of people should not be involved in this. What I think matters is the integrity of the individual concerned and their ability to lead this panel and to do so and do the job that we all want it to do.
David Winnick and then Nicola Blackwood.
I have no reason whatsoever to question the integrity of Lady Butler-Sloss. I'm sure she's given distinguished service in the courts and inquiries. But would you have appointed her Home Secretary if you had known what has emerged later, that her late brother tried to persuade Geoffrey Dickens not to use parliamentary privilege to name someone who he considered, and apparently it was the position, that the person concerned was a paedophile?
Well, a number of issues have obviously been raised in respect of the late Michael Havers. Of course, there was absolutely no doubt that Elizabeth Butler-Sloss was Michael Havers' sister, and that was well known. And indeed, a number of issues around Michael Havers had been raised publicly in the past. What I look at particularly, and will look at, is making sure that the chairman of this panel is somebody of absolute integrity who will be able to conduct an inquiry on which will be doing what we all want it to do, which is to say what went wrong, what should we learn, what more do we need to do.
With respect, you haven't quite answered the question. Were you aware, unless of course it's inaccurate, that Michael Havers, as Attorney General, tried to persuade Mr. Dickens not to raise the issue of the person concerned, name him in the chamber? Were you aware of that particular incident?
Well, that is an issue that has recently been surfaced, if I can put it in that sense. Of course, I was aware of, as I say, Baroness Butler-Sloss's relationship with Michael Havers as Attorney General. But what was important, in my mind, was the integrity of the individual. And I believe that the experience that Elizabeth Butler-Sloss had and her personal integrity was such.
We all accept this. We're all great fans of Elizabeth Butler-Sloss's integrity. That's not a question. What Mr. Winnick has put to you twice is, did you know of this specific incident involving Mr. Dickens and Sir Michael Havers. Did you know about that? Not that she's a great woman with great integrity, we all think she is. Did you know about that incident before you appointed? It's just a yes or no, I think.
This is an issue that has been raised in the last few days and has been surfaced in the last few days as far as I'm concerned.
Do we take that to be a no?
I think I've answered the question the way I wish to answer it, Chairman.
My last question, Home Secretary, because it is a serious issue, obviously, even though Lady Butler-Sloss has resigned, and we respect her decision in so doing. But if she had been a judge trying a case where it appeared that her late brother had been involved along the lines that I've mentioned, wouldn't it be the case that a judge in those circumstances would have immediately resigned from the retired or resigned, whatever it is yes. The appropriate expression, from the case?
There are, of course, certain protocols in place in relation to members of the judiciary when they are trying cases. This is not a question of the member of the judiciary trying a case. It is a question of somebody with the appropriate expertise, experience and integrity being asked to chair this panel. And Chairman, you say that, that this committee has absolutely no doubt about Baroness Butler-Sloss's integrity. But what I'm trying to get at is that the issue, I mean, she herself has felt that she should resign from this position. I respect that. I am disappointed by it, because as I've made clear to the committee, I continue to believe that she was a person who would have led this panel well and would have been able to do so in a way that I think would have commanded confidence from people in terms of coming out, looking at the issues that everybody wanted to see.
It is not her integrity that is at issue today. It is your judgment in appointing her in the first place. She is not sitting before us, you are. So it's quite right that yes. Parliament should ask a Home Secretary what due diligence was carried out, what knowledge did the Home Secretary have about past histories before you appointed someone to head the inquiry. Nobody is questioning her integrity, it's your judgment we're questioning.
But it is exactly my point, Chairman, is that my judgment was about her integrity. And if you are not questioning her integrity,
no.
then therefore that is my point. My judgment is about her integrity to do this job. That's why I appointed her.
With respect, it is not, and I'm sorry to labour this point. The issue is whether you were right to appoint her in the first place, knowing what everyone else knew about the fact that she had these relationships because she was a member of the House. We're obviously not going to win on this, because you think this is a question of whether you were right to appoint her in the first place because of her integrity. Her integrity is out there, we all have great respect for her. It's your judgment and not doing the due diligence that has led to the resignation of someone of great integrity today.
But my point, Chairman, is very simple. That in appointing somebody, you look at that individual and their ability to do the job. That is what I looked at. Of course it was known that her brother had been the Attorney General. There are a number of issues that had been raised about the Attorney General publicly in the past. Of course that was a situation that was known. But it is important that I looked at the individual, and my judgment was about the experience and integrity, and I'm grateful that this committee and that you are clear that there is no question about her personal integrity.
We've never been, I'm sorry Mr Willock, we've never been unclear about her integrity, and you keep going back to this. So let's be very clear with you that this is not about her integrity. When I raised this with Mr Sedwell last week, it was about her being a member of this House and being related to a Conservative politician who was an Attorney General. That is part and parcel of the baggage one gets when one looks at candidates. I've just been sitting on choosing a candidate for the Police and Crime Commissioner for the West Midlands. All the people had great integrity. However, we had to look at their antecedents, who they were connected with, and all these other issues that everyone has to deal with when they're appointing. It's your judgment, not her integrity. Mr Willock.
Home Secretary, slightly differing slightly from the Chair, the fact that she was a member of the Parliament would not have prejudiced me in any way. Neither the fact that her brother happened to be, because she's not her brother, quite separate members of the same family. What prejudiced, I wouldn't say prejudiced, what influenced me is the fact that the brother was involved in the very issue that she was going to look into, namely, the brother apparently had tried for 20 minutes to persuade Geoffrey Dickens not to pursue a matter regarding child abuse and naming that person in a House of Commons. And in my view, if you had probed more, if I may say so, it would have been better for all concerned, including and avoiding embarrassment to Lady Butler-Sloss.
Well, I will repeat the point that I have made. Of course, consideration was given, and there was due diligence was looked at, the issues were looked at. At the end of the day, I judged that her experience and integrity was such that she would do, I believe, a very good job, an excellent job in chairing this panel, and I continue to believe that she would have done, had she felt able to continue, that she would have done an excellent job.
Thank you. We understand that. Nicola Blackwood.
Thank you, Mr. Chairman. Actually, clearly everybody regrets the circumstances surrounding Baroness Butler-Sloss's resignation, but I'm very concerned that we are on the cusp of just disappearing down a Westminster bubble of just process-driven debate on this inquiry and forgetting the fact that this inquiry is about trying to get some transparency and justice for victims of some really appalling child sexual abuse in the past, which they've been denied for far too long. You've already said that you can't give us a date for when you're going to appoint the chair of this inquiry, but there'll be many victims who are waiting to hear when the inquiry will start, what it's going to be about, and to find out what it will mean for them. So can I ask you why you wouldn't consider announcing the whole panel at the same time, maybe after consultation with the chair, because then at least it would speed up the process a little bit, and also then you would have a more broadly based team to announce who might perhaps come from different sectors and might reassure victims that their concerns will be more fairly heard.
I will certainly give some consideration to the proposal that you make, and I can see that there is an argument for trying to announce the whole team and therefore show that there is a breadth of experience there that would take part in this panel. That would, of course, slightly delay the announcement, in that I think, as I've indicated, I would think it right to talk to the chairman once they've been appointed about the membership of the panel. So there would be a slight further delay in announcing. But if it was felt that generally that it would be better to give confidence for the inquiry, for the whole panel to be announced at the same time, I would certainly give consideration to that.
Can I also ask, you've already said that you want the terms of reference to be decided by the panel, but have you considered putting in place already some in-principle agreements of cooperation? Already you've said that sort of all government papers will be released. But I wonder if that how far that stretches back, whether that includes current papers and so on between different departments, and how quickly those will be released on request. Whether those agreements have been put in place, whether agreements about police cooperation and between different forces have perhaps been approached, and also, the crucial one, which is transparency of local government between the different local authorities, because that could take some time to put in place once the panel gets going. And if some of that work could start now, that might actually shortcut some of the problems they would have once they started.
I appreciate the point. I mean, I would hope that we would be able to have the chairman in place and either announce them individually and then the panel all collectively within a reasonable space of time. We're not talking about a very significant delay in dealing with this issue. In relation to the willingness to release documents by other organisations that are not part of central government, obviously government can talk about papers being released by central government. But I think it is important. We have set this up along the same lines, on the same sort of model as the Hillsborough inquiry panel. Indeed, of course, we've set the Daniel Morgan panel up in a similar way. And I think it is very much, we mustn't try to do too much of the job of the panel, because they obviously will have to consider how they wish to go about their business, which organisations, they'll have to determine which organisations they wish to approach, how they wish to do that, in what order they wish to. So there are a number of decisions that they will have to take in terms of how they actually do this work. And I don't want government just to preempt that. I think it's important, it is an independent panel, it's important that we allow them their independence even on matters as how they actually deal with things themselves and how they get documents from people.
Thank you. Can I endorse, in closing this little section on Lady Butler-Sloss, endorse what Nicola Blackwood has said? Originally we were going to have one inquiry headed by one person, in the letter that Mark Sedwell sent to this committee. This became an inquiry to be headed by 2 people, which you announced to the House last Monday. We've now had another inquiry. We believe it's important that you pause and consider very carefully who you want to appoint to chair this inquiry panel. And as Nicola Blackwood has said, there is merit in looking at announcing all the names together with the terms of reference. I don't think you'll get any pressure from this committee for a quick announcement, simply because we've seen what happens with quick announcements. They sometimes go the wrong way. So I do hope that you will consider carefully what has been said by the committee on the personnel issue regarding this inquiry, and rather than hastily appoint someone else, to take time to consult and to appoint others. I know you will say your appointment of Lady Butler-Sloss was not hasty, but we just feel too much is happening very, very quickly without proper due diligence. So perhaps you could bear that in mind. I'm sure that you will have other voices in your ear, but I think this represents the voice of this committee. Can I go on to the Wanless-Whittam inquiry? We had some very interesting evidence from Mark Sedwell last week that he discovered that there were 114 files that were missing as part of the original inquiry, which was set up by him, headed by an unnamed person, because he said that the name was secret. So for the purposes of this hearing, we'll call it the Sedwell review, the first review. He said the files went missing. You said to the House you only realised, or were only told that the files went missing, in October, in answer to a parliamentary question that Tom Watson had asked. Are you telling this committee that between July 2013 and October 2013, your permanent secretary did not tell you that there were 114 files that had gone missing?
I stand by what I said in the House of Commons, Chairman. And I think, you've made the point, you referred to this point earlier. It was very clear for me internally that it was appropriate that this review was done at the instigation of the permanent secretary, that he decided who should undertake that review, and that the full report should go appropriately to the police and not to me.
Okay.
And I think it's absolutely right
and that
any matters were dealt with by the permanent secretary.
We understand that, but it's just a long time to wait to be told, July to October, that 114 files had gone missing. When you found out in October of last year, did you ask a question that I think any of us would ask if somebody came to us and said, you've lost 100 files in your office? Well, what were the titles of those files? Not the contents. I absolutely understand why you didn't want to read the contents, but did you ask the question, what were the titles of those files?
Just as I do not think it was appropriate for me to be involved in the review that was taking place, I think it is appropriate now for me to leave the permanent secretary and, of course, now Richard Whittam and Mr. Wanless to undertake the review of the work that was done. So I have not seen the titles of the files,
no,
and I do not intend to see the titles of the files, so that nobody thinks that I, in any sense, are trying to interfere with what is happening in relation to this review. I think that is important.
Of course, because we understand. What surprised me, in particular, was the fact that you said you didn't want to even read the report because you had heard that it contained the names of Conservative politicians. Now, in the past...
What I said was that there had been, obviously, there were suggestions around in relation to the names of Conservative politicians. It was at the instigation of information that was put into the Home Office by a Conservative politician.
Sure.
And there were certain suggestions being made about that other politicians were involved. And that's why I felt it was not appropriate for me to be involved in the review.
Your precise words is, I did not see the full report for very good reason. The matters that lay behind the report were allegations that senior members of Parliament, and in particular senior Conservative members of Parliament, may have been involved in those activities. It is possible, is it not, for you to see a report on process without seeing any names. I'm just referring to the number of times we've written to the Home Office to ask for reports, and you've written back to us redacting confidential names. Isn't it strange that the Home Secretary, in charge of this very, very important department, we understand why you may not have wanted to see names, but was not interested in the processes contained in those reports, not even interested how those files went missing?
Well,
you didn't even ask for a redacted report.
Well, Chairman, I think I have always taken the view in relation to this matter that what is important is that everybody is able to have confidence that the work that was being done with absolute propriety, and that there was no suggestion of any interference which could have led to any suggestion that somehow information was being kept back because of the implications it might have in a political context. That's why I don't think it was right for me to be involved in the review, or indeed to be questioning the review in the sense that you refer to. I think the Permanent Secretary did absolutely the right thing last year. It was made clear in Parliament, it was made absolutely clear that that review had taken place. Now, obviously, the questions have been raised, and it is absolutely right that there is a further review taking place. Now, I did, of course, in this one, get involved to the extent of saying that I thought it was appropriate that, as well as the senior legal figure, who Mark Sedwell was clear would be leading the inquiry, that there should be somebody overseeing it who had a confidence of those people who are victims and those people who are concerned about what might have been going on. And that's why I suggested that Peter Wanless be asked to...
So that was your choice, Peter Wanless?
Yes.
Yes. Lorraine Fulbrook and then Michael Ellis.
Home Secretary, on the Wanless-Whitton review that has been commissioned to look at the work commissioned by the Permanent Secretary Mark Sedwell, is it not the case that it's also looking at the work of whether the police and prosecutors handled the information correctly?
Yes, that's absolutely right. It will go slightly further than the original review. So the original review just looked at how the Home Office handled matters, but there are two ways in which this review has been extended. The first is that it will look at whether the police and prosecutors handled matters appropriately. And of course, because the prosecutors come under the remit of the Attorney General, yes, in matters relating to them, it will report to him as well as to me. And then secondly, it will also look at the work that the Home Office did earlier this year, to look at the suggestions that have been made that the Home Office had in the past made grants to the Paedophile Information Exchange. There had been some questions raised about that organisation, about its relationship with government, and a review was done about that as well. That has been, a report has been published, but this new review will look to see that that was done properly too.
Yes, absolutely. Thank you.
Thank you. We'll come back to the PIA in a minute, Mr. Austin. Mr. Ellis.
Thank you. On the files, Home Secretary, these 114 files, I raised this issue with the Permanent Secretary of the Home Office when he came before this committee last week. I raised the issue of the file titles, which he's addressed in his letter, which the Chairman's referred to, and you've spoken about. But I also raised the issue of the serial number of the files, and in as much as if we can ascertain with these missing files that the files next to them in the registry are still there, that would imply a conscious hand in having removed those files. It doesn't necessarily indicate malevolence, but it does indicate a conscious hand as opposed to just lacklustre file keeping. He's been silent as to his answer on that point in his letter, and I wondered whether you have any clarification for us. There's 114 child abuse related files missing. If a file is numbered number 30, for example, but number 29 and 31 are still in the files, and number 30 has been taken out, and that's the case with 114 files, that would be relevant, wouldn't it? Do you have the answer?
I understand the point that you're making, Mr. Ellis, but again, I think this is a matter for the Permanent Secretary to consider in relation to... I see he has written further to the committee, most recently on Friday. I would just say, as he identifies the files, or the term he uses for the files is 114 potentially relevant files. He has not addressed the point about but I think that from the letter that Mr. Sedwell sent in at the end of last week, the intention now is that these matters, any matters and questions relating to these files, are now a matter for the Wanless-Whitton review. Information, of course, subsequently will be made available because they will be reporting on there, but I think it's appropriate for them to look at these matters, and so it is now for that review to look at the handling of these files and potentially to identify the sort of points that you're raising.
And will the Wanless review also look at the issue of copies of those files that might have been made by the security services? Now, this is another point that I raised with Mr. Sedwell, because it's my understanding that it has been the practice of the security services in files relating to members of Parliament to take copies for their own archives. And I'm wondering whether 30 years ago copies were taken of some of these missing files and they might be in an archive somewhere else. And I wonder if that would also be encompassed within the Wanless Review.
I was looking for a phrase that I think did appear, but I can't see in the letter. But I mean, the intention is that the review that is taking place, the Wanless-Whittam review, will look to see that the original work was done properly, but also, of course, will look to see if there are avenues that should be pursued that were not pursued as potential ways of finding access to these files.
Thank you.
And even though you don't want to know the contents of these files or the names of these files, even in a redacted form, which is what this committee has been promised by Mr. Sedwell, and can I say that Mr. Sedwell has always been very open and transparent with this committee, provided us with all the information that we require within the deadline that we ask for this information, unlike other parts of the Home Office. You don't want to know the process as to how these files went missing. I understand you don't want to know the contents, but the process is not of interest to you?
It's not a question, Chairman, of whether I want to know something. It's a question of whether I think it is preferable in the situation that we have that I ensure that nobody can question the independence of the work that is being done in the Home Office to look at both processes and the relevance of these files and whether they were handled properly.
No, I understand that. No one's saying you should go around interfering. After all, you're just the Home Secretary and he is responsible for the management of the department. But don't you want to know how they got lost? Not the subject matter. But if somebody came to me and said there's 114 files missing in my office, I'd like to know, maybe not the titles, though of course I would ask for the titles, well, how on earth did we lose these files? Because I don't want to lose any of these files again. Not these files, but any files.
Chairman, the processes in the Home Office for the retention and indeed deletion of material, because government does destroy material from time to time, that files are looked at and destroyed. But the whole point about these files is that they are, they're not there, but nobody knows whether, I mean, the point is they are presumed destroyed, but the review did not identify whether they had definitely been destroyed, whether they had been lost, or what had happened to the files.
I see.
The further review will now be able to look back at that to see if there are other avenues that need to be looked into in order to see whether it is possible to identify either whether these files do exist in some form somewhere else, or to identify what actually happened to these files if they do not exist.
So basically the military equivalent would be missing in action, but they might return, they might turn up somewhere.
Well, as I said, because it isn't, as I understand it, nobody is able to say absolutely what has happened to the files, therefore the review needs to look to see if it is possible to identify further what did happen to the files.
Indeed. Mr. Austin has a question on the PIE.
I'd like to ask whether you were surprised to discover that the investigator appointed to examine claims that the Home Office had funded the paedophile information exchange didn't bother to interview Mr. Tim Hulbert, who was the whistleblower who'd raised the concerns in the first place.
Well, I think the point of the review, as I understand Mr. Sedwell set it up, was that the individual looked at the Home Office and whether the Home Office had at any stage funded the PIE. There was no evidence that the Home Office had directly funded the PIE. There was evidence that the Home Office had provided small grants to two organisations that had some dealings with the PIE, but no evidence that the money that had gone from the Home Office to those organisations had gone through them indirectly to the PIE. So he was looking at the question of whether there was evidence that the Home Office had funded the PIE.
But how can you accept that when somebody who was a Home Office official in the 1970s says he recalls seeing these applications and he wasn't, and the investigator didn't even bother to question him on it? I mean, this was the whistleblower who raised those concerns. I don't understand how you could accept this sort of the assurance that funding couldn't have been provided when they didn't even bother to speak to him.
Well, they looked within the Home Office to see if any Home Office funding had been provided to the organisation in question. They reviewed the archived and open source records. I understand, did hear evidence from Home Office staff. Looked at files available. I understand.
I don't think you. I don't think you've looked into this.
Chairman, yes, I have looked into this. If Mr. Austin would just wait, Chairman. I am aware of information.
If you wish to consult your notes, please do so. We will wait for you. There's no problem.
Well, I think it might be appropriate, Chairman, if I was to, given that this involves an individual, if I was to consider this and perhaps write to you as Chairman in relation to this matter. The matter is not quite as Mr. Austin has put it to the committee.
If you could do that, Mr. Austin, I think that would be very helpful. If you could do that, that would be extremely helpful. You have a very quick question, and then we must move on.
Just a quick question, Home Secretary, on the issue of the 1970s alleged funding of by the Home Office of the Paedophile Information Exchange. This report that's been referred to, has there been any delay in the release of that report? And as far as you're aware, has that been released in good time?
I think, yes. I mean, it wasn't released immediately, but there's been no question of it being held onto for any particular reason. I mean, we did, obviously it was going to be released at some stage, and given the interest in this matter and the statement I was making last week, we felt that that was an appropriate time to do so.
Thank you. We will, as a committee, be calling both Mr. Wanless and Mr. Whittam to give evidence to us at some stage. We had actually sent a letter to Lady Butler-Sloss, but obviously she won't be coming now. Let us move on to emergency legislation. Could you pass on my thanks to the Prime Minister and to others for briefing me, and I subsequently briefed the committee on the conversation at number 10 last week. We know this is emergency legislation. The Prime Minister gave me an assurance, which I have passed on to the committee, that this is not, in his words, a land grab. There is no question of more powers being sought. These are existing powers for existing work of the National Crime Agency and the security services, and there is no question of us going beyond existing legislation. The reason why this has to be done as an emergency is because of judgments made elsewhere. Is that the case?
Yes, Chairman, that is absolutely correct. We have certain capabilities that are used in the vast majority of cases in relation to serious crime and in relation to major investigations into terrorism. Those capabilities have come under threat. I mean, particularly the judgment of the European Court of Justice in relation to the Data Retention Directive does affect the ability potentially to retain communications data. We're clear that our data retention regulations currently stand and continue to stand, but we feel it is imperative on us to put that into primary legislation. They're currently on secondary legislation. We'll be putting that into primary legislation through this bill. And the other capabilities in relation to lawful intercept, it is the case that it has always been regarded that RIPA, or from government circles certainly, that RIPA had an ability to operate extraterritorially, i.e. to serve a warrant on a provider that was overseas, and that there was a wide range of providers came under the definition in RIPA. This has been questioned, and we feel it's appropriate to therefore put that beyond doubt in terms of legislating. But these are powers and capabilities that exist today, that are used today.
Yes.
It is not about extending those into any new remit.
The committee supports what the government is doing in respect of a review of RIPA. We have suggested this in so many reports that we produced that it's not fit for purpose. It really does need to be looked at again. Now, you are setting up a Privacy and Civil Liberties Oversight Board. I assume that Lady Butler-Sloss is not going to be one of the candidates to sit on this board. Have you thought of names to put on this new board?
Lord Carlisle?
The intention is that this will be building on the work that is currently done by David Anderson as the independent reviewer, who took over, of course, from Lord Carlisle as the independent reviewer of terrorism legislation.
So do we have names, basically?
Obviously, it is important for us to discuss with David Anderson, as it is his work that it will be building on, how this should be taken forward. Sure. Names will be announced once the structure of the board and the names will be announced in due course.
So you have David Anderson. This committee is also on record as saying he needs more resources, because I think he has a desk in an office somewhere where he does his work as the on counter-terrorism. We've said this in the past. So he will take the lead and the board will assist him. Will you be clearing names with David Anderson, or will you be making your own appointments, and presumably they will include civil liberty organisations? I don't want you to name names today, but the types of organisations that you anticipate might be sitting on this board.
I don't intend to name any names about any body or anybody who might be involved in this. It is right that we should be able to discuss that with David Anderson properly to ensure that we get, from his experience and expertise of the current role that he plays, we make sure that we get this right in future. But the intention is that there is a body that would advise the government on the, if you like, the balance, the appropriateness of legislation that is in place, and advise the government on privacy and civil liberties concerns, as well as looking at the capabilities and requirements.
Thank you. Dr. Julian Huppert.
Thank you very much, Chair. Home Secretary, I think from our previous discussions over the Communications Data Bill, you know where I come from on many of these things, and I'm very pleased that's not what's at issue here. I have a number of questions. They're mostly, I hope, factual questions, which are just establish some of the basis because time is quite short. Can I firstly pick up on the Chair's question about the no new powers things? I think that is quite important. The wording of the legislation is very complex, and while I totally accept that the intention is not to have new powers, if you do find at some point that there were new powers which had been brought in, if somebody brought a warrant that couldn't have been brought previously, would you be prepared to ensure that you would inform this committee at least, so that we knew that something had somehow gone wrong?
Well, one of the issues that was raised during the when I made my statement on this matter last Thursday, one of the questions that was raised, in fact, by the Shadow Home Secretary, was a question of perhaps looking at the operation of this Act once it's an Act, and having regular reports about the operation of this Act. And that is obviously an issue that has been raised. But it is absolutely the case. The legislation is often quite complex in its language, but it is absolutely the case that this is about taking what powers we have at the moment and putting them into the primary legislation, plus some secondary legislation as well, to back that up, but having the core in the primary legislation to make absolutely clear the position.
So if you were later to discover that somehow that had been misdrafted, I'm not suggesting it has been, you'd be prepared to tell us that somehow that had been done incorrectly?
Well, what I'm saying, Dr. Huppert, is that I think one of the questions is if that were to be the case, and I certainly do not believe that will be proved to be the case, but of course the whole question of how our legislation operates is subject to a number of various arrangements at the moment in terms of oversight. One is, of course, the general oversight of the current reviewer of terrorism legislation. Then you've got the ISC, but then crucially the commissioners' roles, who are looking at a very practical way at how warrants are being served, and will therefore be looking at how those warrants are being served against this new legislation.
And I think they will have heard what the intention is. Just one very last specific question on this particular issue. It's been suggested that in some way this is trying to authorise some things that were revealed by Snowden. Would this legislation have any change in powers over non-US undersea cable companies?
I know there are those who are trying to suggest that this takes us forward in some sense and addresses issues that have been revealed. It genuinely is about ensuring that the powers and capabilities that are there currently are able to continue, given the importance of those powers and capabilities. And CD has been used, I think it's in something like 95% of cases handled by the Crown Prosecution Service dealing with serious crime. This is not just about looking into things, it's actually about prosecuting criminals. So it is certainly not intended to do anything other than ensure that the powers that currently exist in relation to communications, data retention and in relation to lawful intercept continue.
Thank you. The reviewers will have heard that. Can I then move on to issues about the timescale? Why is it happening now and in such a rush? It seems there are two...
Well, the Home Secretary answering questions there to the committee in the House of Commons, Theresa May insisting she does not regret the appointment of Baroness Butler-Sloss to chair the inquiry into allegations of historical child sex abuse by establishment figures under fierce questioning, that coming after the former judge stepped down following much controversy over her selection. So Theresa May continues to be questioned by the Home Affairs Select Committee. We'll bring you more on that and the top stories after this short break.
How we respond to that judgment from the ECJ. Of course, that judgment...